Today's episode might be the last in the inheritance series, so we'll now summarize everything from those episodes combined. The steps heirs and testators must take to distribute the estate to those who deserve it, in a way that pleases Allah Almighty. These steps are split into two parts: testator actions before death and after. The first thing a testator must do before death is write a will focusing on the vulnerable among their children and dependents. They should identify who is weak, whether physically, financially, unable to marry due to lack of money, socially low status, or someone with no voice because they're oppressed. Socially speaking, they should try to leave a portion of their wealth to these vulnerable individuals to compensate for their weakness, helping them overcome it as much as possible while also respecting others' rights. Others are Clause 2 groups: children, testators' vowed wards included in the will, guardianship cases like secret marriage spouses, and wards raised by another after their early upbringing. Somewhat delayed. If kids aren't biological offspring or parents aren't guardians, or kids equal offspring and parents equal guardians, birth parents are caregivers. So no separate roles. Spouses apply too if the testator is male or a woman writes her own will. A testator's spouse and siblings are entitled to an estate share. They have two options: leave all assets to vulnerable dependents so nothing remains for standard inheritance rules, or, you see, this scenario applies either when inheritance law is in effect for him, or when the testator knows that a certain person's circumstances will be stable and secure after his passing. For example, if he has 3 daughters who will receive the largest share of his inheritance, then he has no need to worry about their well-being down the line. So then, what exactly should he do in this situation? It is recommended that he set aside a portion of his entire estate to be given to one of these specified groups, to some number of these groups, or to the vast majority among them. He'll set aside part of his will to adjust their small inheritance share. He won't leave to his 3, 4, 5 daughters. They have strong legal inheritance standing, but to a vulnerable relative like his brother. He knows his brothers won't get anything after his death since he has children. What should he do then? Well, he advises setting aside a portion of his estate to be left to his brothers, for example, and so forth. Now, there is a very important, even dangerous key point that we must address. The original foundational rule is that a will should never ever exclude the groups we just spoke about. So these are the grandchildren we mentioned earlier, vulnerable young children, and all of these core categories that we summarized using the religious verses that specifically describe parents and family relatives. It is absolutely imperative that you never exclude these individuals from a will under any possible circumstances. You see, it is not permissible to, for example, leave all of your entire wealth to a dog, or to bequeath your inheritance to people who share no blood relation or familial connection to you whatsoever. This sort of arrangement is entirely invalid. Now, that is not the correct thing for you to do. Instead, you need to focus all of your attention solely on the specific individuals that we have just mentioned right now. But if you want to go slightly beyond these groups, first, think about those who have a natural right to a share, even if they don't show up for distribution. You see, these claimants have an inherent natural right to receive their share of your estate, even if they are unable to attend the formal property division proceedings. Since you are creating your will while you are still alive, you can start right now to designate a portion of your estate to leave to them in your will, even if they never show up to that division later on down the road. Now then, the eligible categories that come right after the primary inheritance groups are your beloved orphaned family members and the destitute poor people whom you know very intimately and well. These are exactly the groups that you are permitted to include within the terms of your last will and testament. You see, these groups actually hold second priority status, ranking just below those main basic groups that we've been discussing. You must not give these groups too much and leave main heirs in need, unless there is a necessary human ethical reason to give to someone outside. All these groups, not a friend, orphan, or relative. Then study the case carefully to feel at peace with your decision. If you deviate from what's customary in a Quranic will, you can do so, but it must be for a good cause that earns reward, with an ethical or religious goal. However, if you bequeath your wealth to places of luxury, entertainment, or triviality, you put your afterlife in great danger. The will is valid. You are the one bequeathing and the owner, but your motives behind the will shouldn't be trivial. You must know that you are responsible before Allah to make this will solve real problems for people. There are hungry people, people with problems. You should improve their situation, not give this world's money to wealthy people who don't need it. But if, for example, you support a certain sports club, or you are fond of watching a specific artist and bequeath a large part of your wealth to them, all this puts your afterlife in danger. Now let's move to the duties. After the deceased passes away, the heirs first check if there are debts. The first thing they do is pay off these debts from the estate left behind. For example, if the estate was 1,000 and debts were 500, the remaining 500 is what the will applies to, like bequeathing a quarter to someone or an eighth to another. All this is taken after paying the debts. If there's money left after paying the testator's debts and applying the will, then this remaining money is subject to inheritance law. If inheritance law says half, so that means half of what's left after debt payment and will application. Here, the heirs have three groups to focus on. Children, parents, spouse, three groups, not like you mentioned earlier, parents, guardians, sons, children, wards, and those under a vow of faith. No, here are only these mentioned groups. Among them, they specifically focus on the children and check, does the deceased have 3 or more daughters? Any there? If there are 3 or more daughters, they take their share first, and the rest goes to other heirs, according to God's inheritance law. The remaining heirs include the daughter's brothers, i.e., the deceased sons, who take their share from the remainder, as we explained before. If the deceased, a woman, has no children, then the 1/3 share for 3 daughters isn't given, since they don't exist. The husband gets 1/3, then the rest is distributed to other heirs. So first, we check if there are 3 daughters. If not, we turn to the spouse. If the deceased is a man with a wife, she has no priority here. She takes, like other heirs, no priority. If there are no 3 daughters and the deceased woman has no husband, then each person takes their share with their own priority level with others. If their shares conflict, the calculation is first for children and parents, then second priority, lower level, for spouse or siblings. We have 2 verses. Verse 10 first mentions children and parents. Verse 10 second mentions spouse and siblings. Siblings aren't considered if there are children. The spouse, wife, gets a share even if there are children. But children come first, and parents, if present, then the remainder goes to the spouse. Why? If it said the wife's share is, for example, an eighth. Why, if it doesn't conflict with children's or parents' shares, in our colloquial language, we call this a conflict, but you don't have to. We can rephrase. The remaining estate is first distributed exclusively to children and parents, then the remainder to the spouse. If the deceased has no children, siblings are included. If the deceased has no children, no parents, no spouse, only siblings are heirs. Then sibling share increases a lot, but maybe after all these calculations, there's still a remainder. This is very normal because there are groups without a fixed inheritance share who should get something based on heir circumstances and their needs. For example, guardians, if not parents, are different from parents. Guardians don't get inheritance, so they should get from the remainder. Now, think of this like a consolation gift or a thoughtful goodwill gesture. While these loved ones are indeed supposed to receive something meaningful, this is not a set fixed amount that is clearly defined for parents under formal inheritance law. Instead, it is merely a consolatory sum that is determined based on either their own personal financial circumstances or the unique circumstances of the other heirs involved. Additionally, this broad group of eligible recipients includes biological children, legal wards, and foster children, a customary wife, such as a spouse who is kept in secret, as well as parents, a legal spouse, and siblings. Each and every one of these individuals is entitled to receive their rightful designated share in accordance with official inheritance law. But if their share is small or non-existent, they should get from the remainder. Also, groups like the deceased's close friends, who are relatives, orphans whose father died and the deceased was supporting them, and the poor who struggle to find food, all these groups, guardians, relatives, the 7 groups, wards, those under a vow of faith, plus these groups. So these three groups should also get something if they attend the distribution. If they don't, it's not obligatory. But giving them something is nice. It's normal to have a remainder to give these groups more. Maybe the remainder is enough for a reasonable amount, or heirs might donate from their shares by agreement. If their share from the remainder is small, no remainder or little, heirs agree to give from their shares. The summary: all these groups should get something, but some have fixed amounts from verses, others don't. This depends on agreement, consultation, possible judgment, or a person's discretion. As for the remaining key solutions, in the end, as long as these heirs seek Allah's pleasure, research and study all the points we covered today in the summary, and act with conscience and faith, there's no need for further anxiety. Whatever the heirs agree on unanimously and are satisfied with, Allah will never hold them accountable, because Allah doesn't want a specific person to get a fixed amount. Instead, He wants the core of the matter to be realized. The spirit of the issue achieved. Inheritance is very similar to prayer. The Quran didn't mention many details about movements or prayer form, but focused on its core and spirit. Prayer is about humility and such. Similarly here, you find peace not in specific numbers, but in knowing the spirit of Sharia is applied and the spirit of helping others is fulfilled. So this estate goes to deserving people. The matter is settled as long as all heirs are satisfied. So as we saw, it's very natural to have a remainder, since there are other groups to give to, but their amounts aren't specified. After studying all this, rest assured, Allah is pleased with you for doing your duty. No need for more anxiety.